I am Ramakrishna Das, Assistant Professor of Law, National Law University, Odisha. Today we will discuss about culpable homicide not amounting to murder. Homicide means killing of a human being by a human being. Homicide is the highest order of bodily injury that can be inflicted on a human body. Since it is considered as the most serious harm which may be inflicted upon another person, it backs maximum punishment. Under Indian law and US law, which imposes death penalty, whereas English law proposes mandatory life imprisonment. However, in every case of homicide, the culprit is not culpable. There may be cases where a law will not punish a man for committing homicide. For example, death caused in exercise of self-defense, by reason of mistake of fact, bona fide execution of law, etc. are some of the examples. Likewise, if death is caused without any criminal intent or by an accident or misfortune, the man will be excused from criminal liability. On the other hand, if the killing is not justified either by law or facts, the accused will be prosecuted and punished under law. Hence, homicide may be lawful and unlawful. Lawful homicide may be classified as excusable and justifiable homicide. Unlawful homicide may be divided into three categories: culpable homicide, death caused by rash and negligent driving, and the last one is suicide. Under Indian law, culpable homicide is classified into two. One is culpable homicide amounting to murder, and another one is culpable homicide not amounting to murder. Under English law, there are several homicide offences such as murder, manslaughter. It includes both voluntary and involuntary, infanticide, death by rash driving, and suicide. Let us see what the definition of culpable homicide or what section 299 says about culpable homicide. See, as I said, in common law, culpable homicide means crime of killing someone illegally but without intending or planning to kill them. The residuary of the culpable homicide, after the special characteristics of murder have been taken away from it, is culpable homicide not amounting to murder. The definition of section 299 of the Indian Penal Code says the main ingredients for the offence of culpable homicide are following: causing of death of human being. The second one is such a death must have been caused by doing an act with the intention of causing of death or with the intention of causing such a bodily injury as is likely to cause death or with the knowledge that the doer is likely by such act to cause death. Further explanation 1 provides for the situation where the injured person is suffering from some disorder, disease or bodily infirmity which quickened his death. Explanation 2 provides for a situation wherein a person who has been injured could have recovered and escaped death if he had been given prompt and medical treatment. Explanation 3 states if the death of the child is caused when he is in the womb, it is not culpable homicide. However, any portion of the child comes out of the mother's womb, even if it is not fully born, and if death is caused to such a child, then it would amount to culpable homicide. The murder provisions of the Penal Code are part of broader categories of culpable homicide offence under 299. Hence, we can say every murder is necessarily culpable homicide as well, but not vice versa. The word intention in clause A to section 299 IPC has been used in its ordinary sense. Volitional act without being able to foresee the consequences with certitude. An act is said to be intentional when it is done with the desire that certain consequence will follow it. When the result is substantially certain or inevitable, no difficulty arises because in such cases one can resume from the circumstances of a case the consequence to be intended. As a general rule, every sane person is presumed to intend the necessary or natural and probable consequence of his acts, and this presumption of law will prevail unless, from consideration of all the evidence, the court entertains a reasonable doubt as to whether such intention existed. Intention under 299 does not always necessarily mean premeditation or pre-planning to kill a person. The requisite is that the act of the person is likely to result in death is sufficient to constitute intention. It is presumed that every man for his every act expects certain consequence unless contrary is proved. So, if a person in performing some act either expects death to be the consequence thereof or expects a dangerous injury to be the consequence of his act or knows that death is likely consequences of his act, and in each case death ensues, his intention in the first two cases and his knowledge in the third renders the act of homicide. It was held in Muhammad Arif vs. State of Uttaranchal. A guilty intention or knowledge is thus essential to the offense under this section. Intent and knowledge in section 299 postulate the existence of positive mental attitude which is of different degrees. In a very noted case, State of Andhra Pradesh versus Raivarapu Pananya, the Honorable Supreme Court recognized three degrees of culpable homicide, such as culpable homicide of lowest degree, which is punishable with a fine only or with imprisonment up to the limit of 10 years or with both; culpable homicide of second degree, which is made punishable with imprisonment up to a limit of 10 years or with imprisonment of life, to either of which fine may be added; and the third one is culpable homicide of highest degree of murder, which is made punishable with death or imprisonment for life, to either of which fine may be added. In a difficult case where the defendant may not have acted with the purpose of killing or causing grievous bodily harm, but that was extremely likely the result of defendant's actions, then the injury should be given the ruling's directions that the jury may find intention only if the death or grievous bodily harm was virtually certain result of defendant's actions and the defendant realized this. The same proposition was taken by the Supreme Court in Moti Singh vs. State of Uttar Pradesh, that the connection between the primary cause and death should not be too remote. The presence of intention is always a question of fact. Direct proof of intention is always very difficult to obtain. However, in Chachat Khan vs. State of Haryana, the Supreme Court held that when injuries are inflicted on vital parts of body like abdomen by the lethal or sharp-edged weapon, the irresistible inference is that the accused intended to kill the deceased. The first illustration of section 299 explains that even if the act of a person is not intended or aimed at any particular person, it would amount to culpable homicide. Illustration D2 clause of section 300 also gives an example of a person randomly shooting into a crowd and killing one of them. He is said to be the guilty of murder. Both these illustrations are the best examples where the offenders did not have intention against any particular person. In Kashiram vs. State of Madhya Pradesh, in which the accused fired a shot at a particular member of the adversary's party, but it hit another person and killed him. The court applied the doctrine of transferred malice to hold him guilty under section 304, part 2, as he neither aimed at nor intended death of the deceased persons. Another important ingredient under section 299 with the knowledge as a mens rea. As I had discussed earlier, the third degree of intention contemplated under the definition of culpable homicide is knowledge. In the scheme of this section, the least or the minimum degree of mental element contemplated to make an act of homicide culpable is the knowledge that the act is likely to cause death. It denotes the state of consciousness of certain facts in which human minds remain inactive. The offender should reasonably expect that the consequence of his act would result in the death of the person, even if he doesn't intended to cause death. The word likely denotes a lower degree of likelihood of death. The word likely in section 299 conveys the sense of probability as distinguished from merely possibly or probability. This was held in Rajpal vs. State of Haryana. In a very famous English case, R vs. Cunningham, where the House of Lords upheld the conviction of a defendant who killed a victim by hitting him on the head with a chair. Even though there was no intent to kill, the defendant intended to cause grievous bodily harm, and that was sufficient for a murder conviction. Historically, mens rea for murder has been described as malice afterthought, although this is a misleading phrase because there is no need to show any kind of malice or ill will. Here the court took a different connotation for the term intention. Lord Ashkit in Cunliffe vs. Goodman explained, intention connotes a state of affair which a party intending does more than merely contemplate. It connotes a state of affair which, on the contrary, he decides so far as in him lies to bring about. Intention and knowledge appear in section 299 are used as alternative ingredients to the offense of culpable homicide. The difference between the two came to be considered by the Supreme Court in Bastev vs. State of Pepsu. It was held by the Honorable Supreme Court. Motive is something which prompts a man to form an intention. Knowledge is an awareness of the consequence of the act. In many cases, intention and knowledge merge into each other and mean the same thing more or less, and intention can be presumed from knowledge. The demarcating line between knowledge and intention is no doubt thin, but it is not difficult to perceive that they cannot different things. In R vs. Nedrick, Court of Appeal held that knowledge or foresight of the probable consequence of an act cannot take the place of intention. further added, with regard to the mental element in murder, a jury is merely required to determine whether, having regard to all the circumstances, including what he said and did, the defendant intended to kill or do serious bodily harm. It followed that the judge's discretion was wrong because it equated foresight with intent, whereas foresight of consequence could be only evidence of intent to commit murder. Knowledge is a strong word and imports a certainty and not merely a probability, and also attributes intention. A death may be caused either by commission or omissions. In the case of omission, a person will be culpable only if a legal duty is attached to him. In order to ascertain whether omission amounts to crime, the first test to identify is the duties which tend to the preservation of life. These duties includes both legal as well as moral. For instance, duty of the husband to take care of his wife, or son's duty towards parents, doctor's duty towards patient, a fellow citizen's duty towards his counterpart, etc. are the best examples of omission. In R versus James Shepard and another case R versus J.C. Shepard, in these cases, a 16-year-old child died due to some disease, but the parents failed to call the doctor because of their poverty and low intelligence. The Court of Appeal convicted the parents for the willful neglect to take care of their child. However, the House of Lords quashed the conviction and held that mens rea is necessary to prove the guilt of the parents, and the question is whether such a person is aware at the relevant time the child's health might be at risk if it did not receive medical aids, or that parents' awareness of that fact was due to his not caring whether his child's health was at risk or not. Prior to this judgment, the rule in senior's case, that is R versus senior, was in existence that in a statutory charge of cruelty to children, it was sufficient for the prosecution to establish that a child had in fact been neglected, and that state of mind of parent or other custodian are irrelevant. In another unprecedented case, in dog mauling case, Los Angeles court held honor liable for manslaughter, that is culpable homicide, by gross negligence for death caused by a vicious dog. The court rejected the theory of accidents and held that the very act of keeping such a ferocious dog clearly indicates the defendant has acted in a conscious disregard of a non-risk of human life for which he is liable for manslaughter. In Director of Public Prosecution versus Newbury and Johns held, killing by gross negligence amounts to constructive manslaughter. The Allahabad High Court in one case, Brijlal Verma versus SP CBI, expressed its anguish over increasing incidents of police encounters in the country, said that police encounters are nothing but murders and the guilty police officers deserves death penalty. Further, in Prakash Kadam versus Ram Prasad case also, the Supreme Court agreed that encounters amounts to murders. Before going to the punishment part, let us differentiate between culpable homicide and murder. If a person commits culpable homicide, if the act by which the death is caused is done, the first difference is the culpable homicide should be done with the intention of causing death. And in the case of murder, the intention of causing death is important, and with the intention of causing death, bodily injury, as the offender knows to be likely to cause the death of the person to whom the harm is caused. The second difference is with respect to culpable homicide, with the intention of causing such a bodily injury as is likely to cause death, whereas in the case of murder, with the intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. That is very important. And the third difference is with the knowledge that the act is likely to cause death. In the case of murder, with the knowledge that the act is so imminently dangerous that it must in all probability cause death or such bodily injury as is likely to cause death and committed without any excuse for incurring the risk or causing death or such injury as aforesaid. The distinction between culpable homicide not amounting to murder and murder, as it very aptly and ably articulated by Justice Melvini and repeatedly quoted with approval by the Honorable Supreme Court, especially in good number of cases, State of Andhra Pradesh versus Raivarappo, Abdul Wahid Khan versus State of Andhra Pradesh, Chako versus State of Kerala, Shankar Narayan versus State of Maharashtra, and there are a good number of cases the Supreme Court differentiated culpable homicide and murder. Now we will see the punishment under the Indian Penal Code. Section 304 says about punishment for culpable homicide. Section 304, it simply says culpable punishment for culpable homicide not amounting to murder. See, on the basis of the imposition of punishment, the section can be divided into two parts. The punishment prescribed under the section varies with a wide range from imprisonment of life to the imprisonment of mere fine. The varying sentence depends on the degree of intention and knowledge of causing death that is imputed to the accused. The first part prescribes a sentence of imprisonment for life or imprisonment of either description for a term of 10 years and fine for the act by which death is caused is done with the intention of causing death or of causing such bodily injury as is likely to cause death. This part clearly shows that it covers offences where intention to commit the offence is present. However, the second part applies to offences where the act is done with the knowledge that is likely to cause death but without any intention to cause death or such bodily injury as is likely to cause death. The offence under section 304 part is higher degree than that under its second part. The intention and knowledge prescribed under this section is a lesser degree than that which is described under section 300 IPC. Section 307 provides punishment for attempt to commit murder and culpable homicide. To provide this section, two elements are essential. Firstly, intention or knowledge to commit murder. Secondly, the actual act of trying to commit murder. Now we will go for the conclusion part. One of the criticism is both the culpable homicide and murder are not properly defined. The Law Commission in its 42nd report 1972 suggested to redefine section 299 and 300. As I said, section 299 and 300 is the most complicated section in the Indian Penal Code. Since it is most complicated section in the Indian Penal Code, I would suggest we need a very precise definition or a very clear definition for both culpable homicide and murder. Apart from this, it also recommended two proposals with regard to punishment. First one is the punishment of life imprisonment, as it has never been awarded, be deleted from the provisions and only one maximum punishment should be provided for culpable homicide not amounting to murder. However, these proposals are not counted either in Criminal Law Amendment Bill 1978 or in the latest amendment. I hope you understood about the fundamentals of culpable homicide. Thank you.